Welcome to SENDiasss4BCP's webinar on suspensions and exclusions. Today we will be looking at the types of exclusion, when a head teacher can exclude, the steps a school must take, what to do if your child is suspended or excluded, challenging a decision to suspend or exclude, and where to access some further support should you need it. There are only two types of exclusion from a school which are lawful. These are permanent exclusions, whereby a child is not permitted to return to the school, or suspensions, previously known as fixed-term exclusions. This is a fixed period of time whereby a child is not permitted to attend school for a fixed period of time. This fixed period can be anything from half a day. A child can be suspended for one or more fixed periods, up to a maximum of 45 school days in a single academic year. Although not considered an exclusion, guidance on off-site direction and managed moves is also provided within the Department for Education's exclusions guidance. Managed moves and off-site direction are behavioural strategies used to improve a child's behaviour to help prevent a suspension or permanent exclusion. A managed move is a voluntary arrangement between the school, the parent, and the admission authority of the new school. This decision should only be made if it is in the child's best interests. If a managed move is successful, it may lead on to the child then being admitted to the new school permanently. An off-site direction is different in that no consent is required from the parent in order for it to happen. If your child has an EHC plan, then the local authority must also be informed, as there is still the requirement for Section F of the EHC plan to be delivered. It may be used where interventions or targeted support have not been successful in improving a child's behaviour. This must be time limited and can be for part of the school week or full-time at another provision, usually an alternative provision or a school. Parents must be notified in writing of any such arrangement and be provided with information about the placement as soon as practicable after the direction has been made and no later than 2 school days before the relevant day. Informal or unofficial exclusions or suspensions, such as sending a pupil home to cool off, are unlawful even if a parent or carer agrees to it. All suspensions and exclusions must be formally recorded. If a child is not formally excluded, then they have the right to be in school. It is important to note that should a child attend an independent school, including Section 41 schools, a non-maintained specialist school, or a further education setting, these settings will have their own policies on suspensions and exclusions and are not required to follow the guidance as discussed. There is guidance in place with regard to the management of part-time timetables. That is, they should not be used to manage a pupil's behaviour. They must only be in place for the shortest time necessary. They should have a time limit by which point the pupil is expected to attend full-time education, either at a school or alternative provision. There should be formal arrangements in place for regularly reviewing a part-time timetable with the pupil and their parents. And in agreeing to a part-time timetable, the school has agreed to a pupil being absent from school for part of the week or day and must be treated as authorised absence. Only the head teacher of a school can suspend or permanently exclude a pupil on disciplinary grounds. They cannot, for example, suspend or exclude a pupil for academic performance or ability, or because they have additional needs or a disability that the school feels it is unable to meet. A pupil's behaviour outside of school can be considered grounds for suspension or permanent exclusion. Any decision of a head teacher, including suspension or permanent exclusion, must be made in line with the principles of administrative law, i.e., that it is lawful, reasonable, fair, and proportionate. When establishing the facts in relation to a suspension or permanent exclusion decision, the head teacher must apply the civil standard of proof, i.e., on the balance of probabilities, it is more likely that the event or events occurred. Head teachers should also take the pupil's views into account, considering these in light of their age and understanding before deciding to exclude, unless it would not be appropriate to do so. The head teacher should also take account of any contributing factors identified after an incident of misbehaviour has occurred. The law does not allow for extending a suspension or converting a suspension into a permanent exclusion. In exceptional cases, usually where further evidence has come to light, a further suspension may be issued to begin immediately after the first suspension ends, or a permanent exclusion may be issued to begin immediately after the end of the suspension. The decision to exclude a pupil permanently should only be taken in response to a serious breach or persistent breaches of the school's behaviour policy, and where allowing the pupil to remain in school would seriously harm the education or welfare of the pupil or others, such as staff or pupils in the school. For suspensions up to 5 days in a term, without delay, the head teacher must notify the parents of the period of suspension or permanent exclusion and the reasons why. Without delay, this must then be followed up in writing detailing the above. Also, your right to make representations about the decision and how these representations should be made, and the days on which you must ensure your child is not present in a public place at any time during school hours. Work should be set up and marked by the school, and reasonable adjustments should be made in how pupils with special educational needs and disabilities are supported. For suspensions between 5 and 15 days in a term, in addition, the governing body must meet if the total days is between 5 and 15 days in a term and you request a meeting. The governing board may consider reinstatement of your child, and this must be held within 50 school days. You have a right to attend the meeting, to have someone represent you, or take a friend to support you. You must also be informed of your right to have the meeting held virtually. If the suspension is issued for more than a 5-day period, the school must arrange suitable full-time education, usually by way of alternative provision, to begin from the 6th day of suspension. If a child receives consecutive suspensions, therefore totaling more than 5 days, this should be treated as one period, so the above will apply from the 6th day. For suspensions over 15 days in a term, or where your child will miss an external or national curriculum exam, the governing body must meet, and you must be advised of your right to attend the meeting, to have someone represent you, or to take a friend to support you. If you choose to not attend or provide written representations, the meeting will still go ahead. This does not affect your rights in requesting a further review if required. If missing an external or national curriculum exam, reasonable steps must be taken to meet before the exam. You must also be informed of your right to have the meeting held virtually. And the same applies in terms of provision, whereby the school must set and mark work for the first 5 days. If the suspension is issued for more than a 5-day period, the school must arrange suitable full-time education, usually by way of alternative provision, to begin from the 6th day of suspension. If issuing a permanent exclusion, the head teacher must, without delay, notify the parents of the permanent exclusion and the reasons why. Without delay, this must then be followed up in writing detailing the above, and also your right to make representations about the decision and how these representations should be made. It should also include the days on which you must ensure your child is not present in a public place at any time during school hours. Work should be set and marked by the school for the first 5 days. The local authority must then provide suitable full-time education from the 6th day of exclusion. If the child has an EHC plan, this should then be reviewed with a view to identifying a new placement. And a governing panel meeting will be held within 15 school days of the exclusion. To summarise, you may find this table useful to identify what notice should be provided, the governing board's responsibilities, and the responsibility for the delivery of provision whilst your child is suspended or excluded. If your child has been suspended or excluded and they are not in receipt of an EHC plan, and you feel your child has been excluded because their special educational needs are not being met, then consider the following. A review of the special educational needs support which is in place. Is the graduated response being followed? You'll find some further information with regards to a school's duties and SEN support on our website. Check the school's SEN information report. Is there anything further the school offer that can be provided? This must be published on a school's website and should tell you how the school's SEN policy is used, how help and support for pupils with SEND works in that setting, and also what happens and how, not what they aspire to do. Consider an EHC needs assessment. Does your child require more support than what SEN support can provide? If your child is not making expected progress with support in place, this may indicate that further assessment is necessary to identify your child's needs and the provision which is required to meet those needs. Consider a managed move or change of school. It may be that you feel a different school can provide the environmental support that your child needs, in which case you may wish to request that the head teacher considers this as an alternative to suspension or exclusion. Inform the head teacher of your concerns and request that they reconsider their decision. If your child is suspended or excluded and they are in receipt of an EHC plan, and you feel that their special educational needs are not being met, consider the following. Is the plan fully reflective of your child and their needs? And is Section F being delivered? An early annual review should be considered before taking the decision to permanently exclude, or if in receipt of a high number of suspensions. Is further assessment required if the child's needs have changed significantly? Is there any further support the local authority can offer to prevent the suspension or exclusion? And will the head teacher reconsider their decision in favour of an alternative or further support? There are a number of reasons why you may feel that the wrong decision has been made, either to suspend or exclude your child. You firstly may wish to consider informing the head teacher of your concerns. It is usually helpful to work together to work out an alternative solution. A head teacher can withdraw their decision at any time prior to a governing body panel meeting being held. If this does not address your concerns, then you may wish to consider making written representations to the governing body prior to a meeting. You will find further information on this on our Governor's Disciplinary Committee Meetings webinar. If the threshold for a meeting has not been met, you can still provide written representations. However, the governing body will not be able to overturn the decision. You may also wish to consider attending the meeting with the governing body. If the threshold has been met for a meeting to automatically be held and you decide not to provide written representations or attend the meeting, this does not affect your right to request an independent review panel hearing later on if needed. Again, you will find further information on this meeting on our Governor's Disciplinary Committee Meetings webinar. Should the governing body uphold their decision, you have a right to request an independent review panel meeting, or IRP. This is similar to a governing body meeting. However, it is the governing body's decision which is being reviewed, not the decision of the head teacher. It is held with a panel who are independent of both parties, that is, the school and the family. And there is also an option to request an independent special educational needs expert to attend the hearing. You can find further information on this on our Independent Review Panels webinar. If you require any further support with regards to suspensions or exclusions, you can visit our website at SENDiasss4BCP.org, where you will find lots of free resources to support you. You can email help@SENDiasss4BCP.org, or you can contact our advice line, open Monday to Thursday, 9:30 till 12:30.